Ajibola Basiru. I represent also Central Senatorial District. I also stand to support that the bill be allowed for second reading and to go for expeditious passage. The content of the bill is very germane, particularly in advancing the war against violence among gender. Generally, limitation of statutes does not apply to criminal activities. So one wonders what was the rationale for providing 2-month period for instituting criminal proceeding in case of defilement of young ladies and the people who are mentally challenged. So I believe that the rationale, as it may be, if it were applicable when the criminal code was first drafted about 1897 and they adapted in Nigeria, I think in about 1904, is no longer applicable under the present circumstance and arrangement. In fact, as somebody who had cause to prosecute such kind of offense as an attorney general, I know how pretty difficult those technicalities had been used in aid of letting criminal or alleged suspects to go scot-free. So in terms of removal of the statute of limitation, I think it's highly commendable. And I will say that in addition, there's a need to strengthen our evidential situation, particularly as regards issue of prosecution for sexually related offenses. There have been experiences whereby possibly I've had an experience where a youth corporal doctor had the cause to carry out tests on the person that was the victim, but having been completed the service and prosecution was to go ahead, we had the challenge of how do you tender without the maker of that document. So there may be also a need to go further to ensure that whenever such medical record have been put in place and duly certified to having been made by relevant medical agency, it should be allowed to be used and tendered in evidence and dispensed with the requirement of the maker. Then on the question of extension of the offense of rape to be gender neutral, I think it's also part of the innovation that is not based on the traditional conception of what rape is. Of course, much is also to be commended in terms of additional penalty for the offense of kidnapping. And I also think that in making the offense of kidnapping to be far less in terms of punitive sanction than even stealing ordinary chattel, I think it's one of the loopholes in our law that this bill will certainly fill. So I'm happy to associate with the sponsor of the bill and to also urge colleagues to ensure that the bill is expeditiously passed. Thank you, Mr. President. Electronic Law Report 20974 SC. The essence of the decision of the Supreme Court in that case that when it comes to issue of urban and regional planning, it is within the residual powers of the states under Section 4, Section 7. While the philosophy of the proposed bill is commendable, as has been said by distinguished senators, I want to call attention on the need to exercise caution in drafting the bill in such a way that it does not overlap to the area of developmental control. Because from the discussion of the aspects in the lead debate and also from one of the contributing senators, issue was raised about using developmental control to achieve the purpose of the bill, which is flood control and drainages. If that is the case, there may be constitutional issues as to whether the bill is about developmental control or actually environmental law issue. So the essence of the point of order is to ensure that the instrumentality of the law to achieve the purpose and the goal of the bill must not be seen as part of developmental control, which comes within the framework of urban and regional planning, which has been said by the Supreme Court to be within residual power of the state based on Section 4, Section 7 of the 1999 Constitution. Thank you, Mr. President.